Okay guys, big news from the SEC. They appear poised to take one of the most consequential steps that we've seen in many years for enforcement, settlements, and that process, rescinding the policy that bars settling defendants from denying the commission's allegations, aka the gag rule. On May 8th, the Office of Information and Regulatory Affairs received a SEC RIN titled Rescission of Policy Regarding Denials in Settlements of Enforcement Actions. The rule is listed at the final rule stage with no legal deadline, no designation as economically significant, and no Dodd-Frank designation. That sparse entry is kind of interesting. It indicates that the SEC has sent a final deregulatory or policy rescission action to OIRA for review under Executive Order 12866. And if finalized, the action would likely dismantle or materially alter the SEC's longstanding no admit, no deny settlement framework. The policy at issue is codified at 17 CFR 202.5 E, and it provides that the commission will not permit a defendant or respondent to settle an enforcement action while denying the allegations in the complaint or order. The rule also states that a refusal to admit the allegations is treated as the equivalent of a denial unless the settling party states that it neither admits nor denies the allegations. And you'll see that littered throughout lots of settled actions with the SEC for more than 50 years. That formulation has always shaped the SEC's enforcement practice. A settling party typically resolves the case without admitting wrongdoing, but it must also refrain from denying the allegations. And so in practice, the policy has allowed the commission to obtain injunctions, undertakings, penalties, disgorgement, bars, and other remedies without actually litigating liability, while preserving the public narrative that the SEC's allegations had some sort of factual basis. And the pending rule suggests that the SEC is now looking to reverse course on this, right? And this is significant because a rescission of the no deny policy would change the settlement calculus for nearly every SEC enforcement matter. That's a big thing to say, and the reason for that is that for respondents and defendants, the change creates room to settle without surrendering the ability to speak publicly about the case. That matters in most cases because in most cases, there's reputational consequences, and those are as important as the monetary penalties, right? So individuals, investment advisors, broker-dealers, public companies, crypto firms, executives, they often settle because litigation is costly, it's distracting, and it's risky. But under the current framework, settlement comes with this gag rule, this speech restriction that can leave the SEC's version of events as really the only permissible public account of what happened. You can't go on the news or go on your Twitter and say, yeah, but it's not really true, or that's not the whole story, right? So Commissioner Hester Peirce made that point. She's made that point countless times, but in January 2024, there was a dissent that she made from the SEC's denial of the rulemaking petition seeking to amend Rule 202.5E, and she criticized the policy as, a gag rule, right? And it's kind of developed that reputation. And she explained that settlement language requires defendants to not only refrain from denying the allegations, but also withdraw papers that deny them and risk reopening the case if they later breach the settlement condition. The opposing view reflected in then Chair Gary Gensler's 2024 statement supporting the denial of that petition is that the policy protects the integrity of the SEC's settlements. Gensler argued that essentially allowing defendants to settle while denying wrongdoing would undermine the value of the, factual recitation in settled orders and reduce, the deterrent message to the market. The pending final rule appears to put that debate back on the table, this time with the SEC moving towards rescission rather than mere kind of reconsideration of the rule. And There's also been some constitutional pressure, which I've made some videos about in the past, right? The no deny policy has been sustained under the First Amendment. There was a case in particular in front of the Ninth Circuit that rejected a facial constitutional challenge to the rule, but it did so in a pretty narrow way. The court upheld the policy against the facial challenge while leaving open the possibility of future as applied challenges, particularly where the rule might be used to prevent settling defendants from criticizing the SEC potentially more broadly. That matters because the SEC does not need to lose a constitutional challenge before changing the policy here. And agencies often adjust the rules when there's litigation risk or there's skepticism from the judiciary, and there's a public policy reason to reconsider. And I think the Ninth Circuit decision gave the commission a litigation win, but not necessarily an endorsement. And now that the administration has changed, it's preserved the possibility that that policy could fail in the future with a more developed record or a more aggressive enforcement of the speech restriction. And the pending rescission, I think, may therefore be understood as both a policy shift and a litigation risk decision. And so from a practical consequences perspective, I think it's important to note that in the final rule, it rescinds the current policy, and there's several consequences that we can likely expect. First, settlement language would need to change. The standard SEC consent provisions are likely no longer valid. We can't essentially require settling parties to say that they neither admit nor deny anymore. And the SEC might still require admissions in certain cases, but it's not going to be a blanket rule where in every case there's this gag order. And the default settlement architecture is likely to be more balanced and more case by case, depending on the actual facts and the veracity of those claims being alleged by the SEC. So second, I think public communication strategy changes. So settling parties may gain greater flexibility now to explain why they settled, contest the SEC's characterization of certain facts, and state that they resolved the matter for business reasons, right? Because there might be a case that's brought that you agree, and I know this from experience, maybe there's a couple things there that the SEC got right. There may be a couple things that they didn't really get right, and you're settling it all for efficiency reasons, right? And so I think third, the SEC may need to rethink how it drafts these settled orders. If defendants can now publicly deny allegations in certain aspects of these settlement orders, the commission might place greater emphasis on detailed factual findings and admissions in select cases or select aspects of cases, and negotiated statements that preserve the deterrence factor without relying on a blanket no denial condition on every single thing that the SEC alleged. Fourth, collateral litigation could become more complicated. So private plaintiffs, insurers, counterparties, employers, and other regulators often look to SEC settlements as markers of misconduct, right? And so if settling parties can now deny the allegations after settlement, the downstream significance is huge, right? Because the SEC order may become more contested and those particular facts might be contested. Think about disclosures to investors, disclosures to different parties who matter. And so I think finally, it's going to impact the settlement leverage in general, right? The existing rule gives the SEC a lot of leeway in terms of the settlement posture. But I think now that whole factual theory behind what the SEC is doing, now that can be contested, it's going to create an entirely different strategic mechanism for thinking about these things. Very few cases are tried to judgment. That's still going to be the case, I think. And that reality has always made settlement policy more than just a procedural thing. It determines how the SEC converts allegations and their investigations more broadly into public outcomes, into penalties, into settlements, into finality. And so the pending rescission of this no deny policy would not eliminate the SEC enforcement settlement. It would not prevent the SEC from demanding admissions, but it's going to change the dynamic on the SEC side for how they think about publishing these orders and what aspects are the most important to really push on. And this has been happening for many decades, 50 years, right? The bargain has been very simple: resolve the case, avoid an admission, pay the penalty, and don't deny. And this is flipping that completely on its head. Anyway, if you found this helpful, please follow me. My name is Braeden Anderson. I'm a partner at Gesmer Updegrove. I represent clients in the financial regulatory space, in the securities industry, broker-dealers, registered investment advisors, and various other financial institutions. If you have any questions, want to talk more about it, hit me up. Be happy to talk. That's all for now. See ya.